Good afternoon. Thanks for joining us today for the advertising guidelines for ATAS participants. For those of you that don't know me, my name is Naomi Menon and my role here at AFTA is the Head of Compliance and Operations, and I also have the designated role of ATAS Compliance Manager under the ATAS Charter. So just bear with me, I'm just having check on the, yep, okay, everything's working. Thanks, Belle. Okay, so our agenda today is I'm going to just briefly go over the advertising guidelines and why it's been introduced. Then I'll recap on misleading and deceptive conduct and then go through each of the topics that we have put in the advertising guidelines. My goal though today isn't to go over, I did a year ago a consumer law series which included a whole hour on advertising. So I don't want to go over all of that. If you actually want to know more about that, then I'll direct you to look at that later. I really just want to focus today on the bits that are different about the advertising guidelines as compared to the ACCC information. So just to start with, a lot of this information, I just want to go over the structure. It comes from the Australian Competition and Consumer Act, and that's the legislation. And then within that legislation, Schedule 2 is the Australian Consumer Law, which you would all be familiar with, and then the ACCC, who is the regulator of that legislation. So I'll refer to a number of cases that the ACCC have brought, and we'll go over that at the end. Just wanted to go over that. So the ACCC has actually put out a number of documents. Look, some of these are a bit old now and probably do need redoing, but the majority of the information that we focus on for advertising is pulled from these documents that are issued by the ACCC. But what we've tried to do in the advertising guidelines is really focus on the key areas that are affecting agents that we're seeing through our complaint process, and also why we've done the guidelines is to really highlight some issues affecting the industry that aren't covered by these documents. So we've created the advertising guidelines for ATAS participants. It has been approved by the board, and so it is a mandatory requirement for ATAS accreditation. So as I just sort of mentioned before, the purpose really isn't to cover all of your obligations because you'd need a whole day for that. But just really to pull out and highlight the issues relevant to the travel industry and what we're requiring of you. And I've got a disclaimer at the bottom because obviously this isn't legal advice, but you should always seek your own legal advice where required. So the guidelines had an effective date on 3rd of February. That's when we notified all of our members, and there's a 3-month amnesty period. So the enforcement date will be the 3rd of May. And what that really means is that in this 3 months, I'll be working with all of our members if they want help in clarifying their obligations or changing their obligations. I've had confirmation already from a number that a number are implementing changes. But in this 3-month time, I won't be issuing any sort of formal letters asking for any members to substantiate any of their advertising claims. But following 3rd of May, that's when, if we are aware of something that is may breach, then you'll get a letter saying, you know, please explain, basically. So this is an overview of how we've tried to summarise what it is we've done with the guidelines. So at a high level, all of this falls under misleading and deceptive conduct. And most people would be aware of the general Section 18 provision, but there's also a number of other specific provisions that I have dealt with previously in the webinar series. But you'll see at the two ends of this diagram, there's two areas, and these two areas are where we've added this extra line at the bottom of clarification of additional guidelines. So I'll go through those two separately, and that will be my focus today. And then at the end, I'll just briefly touch on those other topics and how they affect travel. So to start off with, and the guidelines start off with, talking about misleading and deceptive conduct in general. So just to recap, the relevant test is the reaction of an ordinary and reasonable member of the advertisement's audience. And it's important to note that when we're talking about advertising, it relates to not just print or television, but it is radio, it's magazines, it's telemarketing, it's everything you do on the web, it's SMS messages, it's in your website. Any representation that you're making, these rules apply. So from a very legal point of view, the test, when it talks about who is this reasonable person, the matter is to be tested by its effect on all who come within the relevant section of the public, including the astute and the gullible, intelligent and not so intelligent, well-educated and poorly educated, and men and women of various ages. And the reason I quote this is because it is important that you have to recognise that you can't assume that your audience has any knowledge or understanding of the way that the travel industry works. And we get this a lot. It actually comes up quite a lot in our complaint process that, you know, consumers like, well, you know, we don't understand about classes and categories and all of this sort of thing. So you have to keep this in mind. There's three other key points I wanted to highlight when we talk about this that will apply to all of the topics we're going to discuss. And that is, there's no requirement that you intended to mislead your consumers. So it's not a defence. It's not necessary to show that consumers have actually been misled. It includes conduct that's likely to mislead. And it's not the audience that you would like, but the audience the advertisement actually reaches. So there's a little checklist in the guidelines, which is a bit of a cover-all of all of the misleading aspects, which is just to sell goods and services on their merits, and look at the overall impression of your advertisement and what would that lay person interpret from that. Who is the audience and what is it likely to mean to them? And as I just said, at a minimum, it's a viewpoint of a lay person with little or no knowledge or experience in travel that should be considered. So that was sort of just a very general touch again on misleading and deceptive conduct. And then the first point in the guidelines is component pricing. So I'll talk about what the ACCC say about component pricing, and then we'll talk about this new addition that ATAS requires. So component pricing has its own section in the consumer law, and basically it says when you present prices to your customers, you must state the total price of the good or service as a single figure, which is the minimum total cost that can be calculated. So this should include any taxes, duties, fees, levies, or other additional charges. So the single price means the minimum total cost that is able to be quantified at the time of making the representation. And an amount is quantifiable if it can be converted into a dollar amount. If it's subject to variation, you're to calculate it based on what information you got at that time, and then advise the consumer that it may be subject to change. So this all comes from the ACCC. This is part of the just general guidelines on applying component pricing. If, however, you promote a price that's only a part of the price, you must also display at least as prominently the single price. So this means the customer should be able to identify the total price in an advertisement if a component's been advertised. So the ACCC has an example in one of their booklets. It's a very generic example, but basically they're just sort of demonstrating here. It says 10-day Get Hot in Hawaii package $7.99, but it says there in a lighter coloured font, plus $1,300 accommodation, plus $1,000 tax and charges, for a total price of $3,099. So what they're saying is because of that size, the $3,099 is the total price. Because that size and font is not as prominent as the $7.99, it's unlikely to comply with the component pricing rules. That $3.99. So what does prominent mean? A prominent single price is one that stands out so easily it can be seen by a consumer, and it's clear and eye-catching and very noticeable, and that you should consider the factors of size and colour and font. So based on all of that information from the ACCC, they're basically saying you need to include any charge or description payable by the consumer to book, plus any taxes, duties, fees or levies and charges. They also note what you don't have to include, which is optional extras. So we would see that a lot in travel. Any components which are not quantifiable. Any amounts that you pay to a third party but aren't passed on to the consumer, so that would just be like a business-to-business payment, and representations exclusively to a business. So that would be like between the supplier and a wholesaler. So what we've added specifically is that where there are mandatory additional costs, and we are seeing this a lot, and we've given the 3 examples of resort fees, mandatory gratuities, and direct payments required to a third-party operator. And I've had a few questions about that, and what that really is like in the example that I'll go through in a sec, is when we say, actually I'll just flick through to the example here. If you had, say, for example, $4,999, but then, you know, on the back page in the fine print it says there's $150 payable to a tour operator in the country or whatever country it is, that wouldn't be correct. But if you wanted to, we talked about the single price, you could do the $499, and as long as the 5140 was as prominent, then that's likely to comply. I'll just go back. So that's what direct payments required, and so we're seeing a few of that people are trying to keep their advertised price down low and having additional payments payable to other parties. I mean, that's truly misleading and deceptive. So if you know what a mandatory cost, it should be included in that main price. And then it's just got some details there, basically what we've already discussed. So we've added to that list, the ATAS additions are mandatory gratuities, resort fees, and the direct payments required to a third party. And we've just been through this. Okay. So this is an old case here. ACCC acts against backpacker travel agents for misleading price representations. It's a little bit old, but the message is clear. So the ACCC say some of these businesses advertise tours to the Whitsundays and Fraser Island for as little as $2.99, when that price did not include mandatory charges that consumers had to pay. Those included things such as insurance, national park fees, Great Barrier Reef, and admin fees. So actually the price was $450. So they didn't disclose that there was that extra $130 payable, and so the $299 was not reflective of the true total price of the package. And so I think in this case they ordered a number of things, including a correction notice, a corrective notice if ordered. You have to sort of admit that you didn't comply and actually you were wrong and the price was actually this. And I think they had to do a compliance program and all the usual things that they require. Okay, so now I'm going to move to two-price comparative advertising. Unless anyone had any, I've got a couple of questions here. So for the cruise industry where gratuities are optional, but they do automatically include in final cabin invoice, do we need to include this in the singular price? If it's mandatory and they're going to have to pay it, then I would say yes. And the thing is we get a lot of complaints about this. The thing is I don't think people are upset if you are upfront about it. It's because they feel that they haven't been disclosed it up front, and they feel a bit sort of taken advantage of. So I think that if it is going to be passed on, it's a little bit confusing the way that's worded, because you're saying sort of they're automatically invoiced. It's not very voluntary in that regard. So questionable, but I'd have to have a look at more details, and I am happy to help, and I do with a lot of people, happy to have a look at anything and provide our lens over it. There's one here too also about, do you need to include the credit card fees in this price? Well, essentially that's an optional extra. I think if you're advertising a price and you were to pay cash, then that would be the correct price. So if you look at it from that perspective, and that's why most people wouldn't, and I have never seen that sort of raised as an issue, because I would classify it as a credit card fee. I'm not sure if anyone has a different opinion on that. So somebody said you can remove the gratuities on board. Well, you need to make that clear to people up front. Again, and we'll talk a little bit about fine print in a minute and disclaimers. So somebody's asking about tours that only include breakfasts. Do you have to work out lunches and dinners as well? I think that again comes down to making sure that the inclusions are included, that, lunch and dinner is optional, and I think most people do a pretty good job of making it clear of what is included and not included. Again, we've had complaints about that issue, but it's because nobody made it clear to them what the inclusions were and that they were going to be out of pocket for that. So I've got loads of questions piling through now, so I'll move on. But what I will do is I get all the questions and I'll do a FAQ and send them out to everybody at the end, and I'll do some more questions at the end if we've got time. So two-price comparative advertising, and this is really one of the main areas that we introduced this. Basically, we have done a lot of work on it, and I've worked with a lot of agents in cleaning it up, but we are seeing a flaunting of the rules, I guess is the way you might want to explain it. So under that banner, we're going to move over to the two-price comparison, which, as you can see at the bottom, it says use of typically and valued up to. And I'm pretty sure everyone will be aware of what I'm talking about when I say that, but here's a couple of examples that I've just pulled off the internet quickly about where people are using this two-price comparison, but instead of saying was, they're saying typically or valued at. So what the rules are and what the ACCC states is businesses often make comparisons between product prices being charged and the company's previous price, which is what we do see a lot of, was, now, and that strike through. But there's also comparisons to the cost or wholesale price, the competitor's price, or a recommended retail price. And what we've added in, which is different in the ATAS guidelines is this valued at or typically priced. And we view that the use of this, the same rules apply as applies to the was now and the strike-through pricing. So businesses that use such statements must ensure consumers are not being misled about the savings that may be achieved. May be misleading if it wasn't sold at the was or other comparison price at significant quantities for a reasonable period. So this is in the ACCC guidelines. This is all part of the consumer law. This is what applies and always has applied to all businesses. Never offered for sale at the was or other comparison price. And that's particularly this area is what the ACCC has targeted. What is a reasonable period before an advertisement? It's a $1 million question that there's no right answer, and it will depend on the circumstances or the case and its facts. But different cases are shown it could be at 2 months or 4 months or 11 months. So you have to look at the circumstances of what it is you're actually advertising. So this is an example from the ACCC, and again, this is a pretty straightforward breach. So a travel agency increases the price of all the package holidays to Asia as part of an Escape to Asia campaign, then crosses this amount out as a was price while putting the previous price as the now price. So it was never advertised at the increased price. So this gives the consumer the impression the holiday package is genuinely discounted when in fact it's never been advertised or sold at that price. And this is misleading under the consumer law. So where AFTA has gone a step higher is we're saying that the use of the words typically and valued at in advertising is deemed to be a two-price comparison, and all of those principles we discussed apply to that. So the use of the words may convey that they're getting a good deal when they're not, and that's what and I think everybody is of the opinion that yes, these prices are essentially inflated. So what we're saying at the bottom there, the ATAS compliance manager requires all participants to retain records where you're using this typically and valued at to demonstrate that those prices. Now, all businesses are required, if the ACCC comes knocking on your door, that you have to be able to substantiate any of your advertising claims. So you should already be holding records to substantiate such claims. And I'll put this in the advertising guidelines that this is not acceptable. So you can't just say, oh, well, we have a look at the market and we look at, criteria, we look at that city and those hotels. It has to be either clearly you've said a direct comparison and who that is, or it has to be that you've sold it for that price and you can demonstrate that. So everybody that I have questioned on this can't demonstrate that. So you have to really think very carefully if you're going to use this. I think the key is, and we'll look at this Trivago case in a second, is it has to be like for like. And I think that's the big question is your comparison the exact same? And it's always going to be different and difficult if you're comparing it to another person's product. And again, consumers have complained to us and do complain to us about this. So again, it will always be specific to the single thing that you're advertising. But we add a little checklist here. So the comparison must be genuine and accurate. The price must have been offered in a sufficient and reasonable number and for a reasonable time before being discounted. You need to retain records and be able to substantiate the offer, whether that be to myself or the ACCC. And so there's some examples there of what to include, and this is in the guidelines. It's also important to note that a sale or a discounted price should only be available for a limited time. So this is really more if you're doing strike-through or was now pricing, or if you're saying something's on sale. This is specifically, the ACCC also talk about this a lot. It's not a genuine sale or discounted if you're going to have that running for a long, long period of time, and that actually becomes the real true price. And any previous price should be genuine and not inflated, so the discount is real. So somebody's just asked here about you could save up to, and yeah, look, that's pretty similar because these rules also apply if you use, say, a percentage, like save up to 20% and whatnot. The same rules apply. You still need to be able to substantiate how that has been calculated and whether it is a true comparison and like for like. We'll go through this Trivago case that recently came out. Even though the case was mainly in the public talked about the rankings of which was the cheapest, it actually also in the talked a lot about like-for-like comparison and strike-through pricing, because they conceded, they've admitted that they have breached the law in this regard. So I've pulled out a little bit of this to explain. So in the case it says a hover over was added in respect of the strike-through price. So if a consumer's mouse hovered over the price, the following text was displayed. It said, strike-through price corresponds to the cheapest offer we received from the most expensive booking site on Trivago for this hotel in your stay days. So I don't know, what do you think? Do you think that that's okay? Well, the court looked at it and they said, well, there's a question whether any statement contained in that hover over would be sufficient to dispel the impression that the strike-through price has made. And that's sort of really important point, because it's sort of saying, well, even if you've tried to put an explanation of how you've calculated it, there's still a question of whether the overall impression is dispelled. And I'll talk a little bit about the overall impressions in a minute too. So they said, the judge said, consumers might not place their mouse over the hover, so they might not even see that explanation. But he said, in any event, it was still confusing to a consumer, and it didn't dispel the impression. And importantly, the hover over didn't actually state that the strike-through price may relate to a different room category. And so Trivago, as I said, admitted its conduct did contravene both Section 18 and Section 29. And so that is important because, again, it touches on the like-for-like comparison and making sure that you are having a like-for-like comparison, but also that, you know, just putting a statement of how it's calculated may not be enough, because it wasn't enough in this instance. And ACCC made a few comments about it. They weren't comparing like with like. They were often comparing a luxury room price to a standard room price. And they go on to say people mistakenly thought they were getting discounts when in fact they weren't. It's absolutely outrageous. So there's the warning right there. There was another case as well at the end of last year. It wasn't travel, but it shows that this is a focus. The retailers used advertising statements such as was 2599, now 2049, etc. And similarly, save $200 when the furniture had never been advertised. I think this is plush sofas, or it was only advertised that that was priced for a short period of time. So again, ACCC makes some comments. Consumers rely on comparative pricing to find the best deal available. If there are no genuine savings, businesses are misleading consumers. Using claims of false savings to induce consumers to purchase products also disadvantages competing retailers, which are complying with the law. And most people and most ATAS agents are doing the right thing and complying. As I said, this is really focusing on some behaviours that we don't want to represent the travel industry. Okay, so I'm just going to have a quick look at a couple of questions. How we're going for time? Not too bad. So sellers to consumers or supply. Look, there's a few questions in there that I'd probably need to have an offline conversation with you, which I'm very happy to do. Someone's asked about from prices, and from prices are, again, fine, but as long as you're being very clear about the conditions. And I'll move on because actually I do talk a little bit next about fine print and disclaimers, which is a very common thing that comes up here. Somebody has asked about how long to record the substantiation, and I don't know if I'll have a look into that if there's an actual level of time, but in some of these cases, when it does come to court, they do go back years, a long time. So I'd be aiming for at least 7, just like your tax. Okay, so I'll move on. Now, there's a lot of interconnection between what we've already talked about and these topics, and there generally is when you're talking about misleading and deceptive conduct. But I'm just going to talk a bit about headline claims and fine print, which is something that we deal with a lot here, and it does interact with what we've just talked about. So again, in itself, a headline claim must not itself be misleading, and this applies to what we've just talked about when we're talking about a price and the value that typically, or whether it be a price that excludes other mandatory payments. So this definitely ties in to component pricing under the general misleading deceptive. Statements referring the consumer to another website or web page or document won't be sufficient to correct a misleading or deceptive headline, and that's really important as well. So there's the dominant message test, and this is central to any assessment when you're looking at an advertisement. So qualifying statements such as in the fine print must be sufficiently clear and prominent so as to not mislead consumers, particularly when it's about price. So, sometimes we'll have a complaint, we go to an agent and they'll say, oh, but look, here in my terms and conditions on page 530 down the bottom in the corner, it says this, so it's all right. That's not ever going to hold up, because you do have an obligation to make sure not only have they accepted the terms and conditions, but that the main qualifying statements are sufficient and clear and prominent. So most disclaimers are often marked with an asterisk or a hyperlink. You'd see them on all sorts of advertising, but a disclaimer shouldn't be used to explain a price representation in further depth. General disclaimers such as terms and conditions apply should be used with caution always. Obviously, in our industry, there is always going to be a lot of terms and conditions, but you do have to make sure that those important ones are made clear, and definitely not to conceal important information. So the 3 points that the ACCC say are: ensure the disclaimer is effective, it must be able to be readily identified by a consumer, placed close to the main price representation, and clear in meaning. Flight Centre, so this was a case, you probably all heard about this at the end of last year. So this is about when making it clear about what the terms and conditions are. So they paid a $252,000 penalty for their Christmas and Easter promotion. This comes straight from the ACCC website. The ACCC had grounds to believe that these advertisements were liable to mislead and breach the Australian consumer law because Flight Centre failed to disclose to consumers that redeeming the $250 voucher was subject to certain conditions. These conditions include requiring consumers to book another holiday with Flight Centre worth more than $5,000. So the ACCC state, businesses are warned that terms and conditions of any deal or promotion must be prominent so that consumers understand what is involved in redeeming the offer. I guess that, to me, is the key takeaway. You know, as we said in the beginning, what would a lay person take away from that advertisement, in particular when you're talking about price? So remember, a consumer shouldn't need to extensively search the advertisement or pages of a brochure for additional disclaimer information. And it's your responsibility to ensure that consumers are clearly directed to and made aware of any fundamental terms and conditions that relate to the travel advertised. And even if it's not advertising, the non-refundable components should always be made clear. Half of the complaints we receive here at AFTA in some way relate usually to a consumer saying they weren't aware of the terms and conditions and of the non-refundable components. So I am just reiterating that because don't want that to happen to your businesses. But by being clear about it up front, you're also making life a whole lot easier for yourself down the track. As I said, people are fine as long as they've been disclosed all the relevant information. Okay, so that's fine prints and disclaimers. The other thing that we've added in is just briefly, just going to go through the next three topics very briefly, is free. Now, the ACCC really warn about the use of the word free. If you're going to use the word free, it needs to be absolutely free. So you may get into trouble if you're doing that and not revealing the complete truth, including any conditions. And that's the reason we added this, because I've seen a few complaints about where there's free cruises or airfares are offered in conjunction with obviously a holiday. So where we're seeing the problems is that free component was used before the paid component was used, then the paid component got cancelled. So if you haven't been clear in your terms and conditions what's going to happen in that event, then you may be left out of pocket, because, again, it needs to be made clear up front in the terms and conditions, and it does need to be truly free. Always keep that in mind. And again, if it's free and then in the fine print it says, oh, you have to pay, $150 to a third party, it goes back to what we talked about with the component pricing at the beginning. No, it needs to be included in the price because it's actually not free. So that's why we have touched on the free. Bait advertising. So bait advertising is where you obviously offer an item for sale at a low price to attract a consumer to a business. And the old bait and switch, which, consumers do bring up to us. Sometimes they feel that they've been baited and switched. So the rules around it are that you must be available in reasonable quantities and for a reasonable period at that price. And you must state clearly if the good is in short supply or on sale for a limited time, which most agents would do and do a good job of that. So the checklist is basically just saying ensure travel advertised is available in reasonable quantities at the advertised price for a reasonable period. And again, you know, reasonable is can be a difficult thing to determine, but it will turn on the facts of your situation. And just make sure you do stay if it's on sale for a limited time. And lastly, I'm not going to talk a lot about testimonials because in the consumer law series that I do, I talk about it quite a lot. It is something to really consider because there's actually quite a lot of action that has been taken by the ACCC for false testimonials. So, and I think in the guidelines I put in the case example of Meriton, who did get caught as well for excluding those bad customers that they didn't want to give a review on. So we just put a little checklist to consider. Do not encourage family and friends to write reviews about your business without disclosing their personal connection. Do not write reviews when you have not experienced the good or service, and do not solicit others to. And importantly, do not selectively remove or edit reviews. That's considered also false testimonials. So if you take off all the bad ones. So be wary of that, and I have seen a number of new businesses or startup businesses might feel they need to do this to, you know, get on the radar on those sort of platforms, but don't do it. There are specific rules and guidelines about it, and actually there's a whole booklet that the ACCC put out about it and about how to do it correctly. So be aware of that. So what's next? Okay, so review your advertising materials with the lens of those new requirements in the advertising guidelines. Look, for the most part, the people that we know are really affected have been contacted and were advised of this. So, but if you're concerned, by all means, let me know. So adjust where required. Retain records for price comparisons. Not sure, ask me, I'm here. I'll give you my email in a minute. And then if you want to, you can always look at those Australian consumer law, the full hour on advertising, which is available on the AFTA website under webinars. And just remember, it's a 3-month amnesty period. So by all means, we're here to help. And the whole purpose of doing it is we want to, you know, AFTA's here to self-regulate our industry. We don't want to see our ATAS participants, you know, getting a call from the ACCC. We don't want to see actions. We would rather address these issues as an industry by ourselves to ensure the standard is maintained. So that is 45 minutes, which was my goal. So I would really appreciate any feedback you have, but this is my direct email, so I'm happy to always assist with direct questions. And as I said, I'll go through all the questions and I'll respond to each of them individually. And if I think that there's FAQs, I'll send it out to everybody. But if you do have any questions, by all means, as I said, please feel free to reach out to me at any time. Let me just have a quick look at some of these questions in a couple of minutes I've got here. Somebody's asked about 2021 brochures. Oh, that could be a problem. Happy for you to maybe send me an email and have a look at it. We can have a chat about that. Is there a service we can make use of for period spot checks of advertised deals? Is there a service we can make use of for period spot checks of advertised deals? I'm not sure if I'm following, if you're looking for us to spot check or yourself on other businesses. Somebody's asked about their use groups, promotions and specials and promotions. You are actually responsible as a business for the representations that you make. So there is an element that you are responsible and liable in that regard. Depending on the scenario, obviously, you know, we can work with somebody, a group, if you do have an issue, because obviously it's best to go to the root cause and have a look at that. But say, for example, I'll give you an example of where that sort of occurred before. We had an agent that was using, the agent was selling their package via Webjet, and Webjet aren't ATAS accredited, and they were using at that time, I think it was typically pricing or valued at pricing. In that case, that was tricky because the consumer had gone to Webjet, but then it was the agent's package that had done the advertising. But then they said, I'm sorry, I'm going around in circles here. They said though that they hadn't provided the number. But anyway, the answer is you are responsible. So, and in that case, even though the agent was in the middle, we negotiated the settlement with the consumer that they were happy with, because, yeah, it was pretty clear that it was nowhere near the valued at price, the services that they got. And that's what you've got to be careful about, this representation. Price representation represents, you know, people associate the level of quality to price. So if you are saying something's worth $20,000 and it was for 10, that, you know, they're going to expect the $20,000 worth. So if you can't deliver that, don't advertise that, because you're always going to get into trouble. Yeah, so a few questions like that. But as a business under the consumer law, you are responsible for the representations that you make, and then it's your responsibility to then go back up the chain to correct it if you have been put out of pocket. You know, so that's a very generic view on that. That there's obviously a bunch of different scenarios within that. Is AFTA working on a solution for non-ATAS providers? Well, that's a really good question. Yeah, look, we are, and we're really, as I said before, we're trying to self-regulate. We've advised the ACCC that we've initiated this guidelines, that we see that this is an issue in the industry, and so we are in discussions with them about that. And we've let them know about this. And so, yes, that is definitely on our radar, because you're completely right. Everybody here is doing the right thing, and if there's players out there not, it's one, not fair to those that are on the level playing field. So we'll keep you posted on that. What will the penalties be like for breaches? Well, as far as ATAS goes, if basically you can't comply with us and we think that your advertising is misleading, deceptive, basically you'd be cancelled from ATAS. What we're saying is this is now part of the eligibility criteria to be a member. So we can't make a determination on what the law is, but that's why we've set this as a standard, so that if we feel, myself in particular, as the ATAS compliance manager, feel that it is in breach, then it's about you'd be cancelled. If the ACCC do come knocking, you could be anywhere from, you know, $10,000 and a corrective notice and a compliance program up to, you know, we saw the Flight Centre one was $252,000. There's a number of other cases afoot at the moment, which I'm very keen to see. But it could be anywhere and up. And, you know, the consumer law penalties are just going up and up and up. It would definitely be disruptive to your business. And as I said, you just don't you just don't want, it's the time and energy and effort when those sort of things happen that is really disruptive to the business. Somebody's asking me some other questions about other things that we're doing. So after doing a road show that we start in the end of March, and we'll be in Melbourne, then Canberra, then Adelaide, then Perth, Sydney and Brisbane, and our whole team will be there. So we'll be talking about all the things that we're doing with government at state and federal level. Joe from marketing will talk about the consumer ads. I'll be doing an overview of all of ATAS code stuff from last year, things that we're working on this year, best practice things, everything that I can cram into 30 minutes. So it will be a really good overview of everything that AFTA is on, and the whole team will be there. So if you have questions about other areas of work that we're doing, pop onto the website and you can register a spot. We encourage lots of employees to come from your businesses as well, so that more people in the business understand what AFTA and what ATAS means to your business. So yeah, so have a look on our website if you on that, and we are working on lots of different things for the industry. But I've hit my 50 minutes now, so I'm going to wrap up there. My email is there, and as I said, I will come back to everyone. I really appreciate your time today. I hope it's been of some assistance, but if not, by all means, please reach out to me and I'll try to help you. Thank you, and please fill out the survey. I really appreciate it. All right, have a nice afternoon.